All right, the committee will come to order. Let's first record our attendance on the screen. All right, thank you. Please close the roll. All right, first bill we'll deal with is Senate Bill 872. Senator Newman.
Mr. Chairman, good afternoon. Mr. Chairman, this committee considered a work group to come together and study ECO and TDO changes. That work met. Most of the work of that committee is in the budget, and you'll see those with crisis receiving centers and other items. This bill relates to two of the items coming out of the work group, and it basically talks about when we will allow for alternative transportation. And this bill basically states that that when you're requested and it's available, it will be approved. That's on the substitute My Line 38. And then the other item, Mr. Chairman, is that this bill indicates that that we will have some type of definition about what type of restraints may be used in those cases. That has been very unclear in the code in the past, but it basically says now that you'll do the most minimal restraint if you're an alternative provider, transportation provider, but you must be under contract with DBHDS, and that you also have got to complete the courses with DBHDS. You have to ensure that it is necessary for the safety of the person or to prevent restraint, and that is the least restrictive alternative available.
All right, thank you. And there are no amendments to the bill that's before the committee. Is that correct, Council? Okay. All right. All right. Questions for the patron? All right. Is there anyone here who wishes to speak in favor of the bill?
Good afternoon. Elizabeth Hobbs with the Virginia Sheriff's Association. We support the bill. We're hopeful that it will reduce the hours of law enforcement waiting with people in hospitals for ECOs and TDOs. Thank you.
Anyone here to speak in opposition to the bill? All right. Okay. No one online. All right. Chairman Bell.
This is either for the patron or the staff. I'm not, Senator, if you don't know the answer, that's fine. We think of alternate transportation as the companies. Is it not the case we also have families, and how would that work? How would that work with restraints?
Mr. Chairman, when it comes to those alternative transportation, you're right. It's family members, friends, CSBs, and the DBHDS contract alternative transportation. This bill, however, states on what is on my line, 145 through 149, that the only ones that are able to use restraints are those individuals that have been approved by the department and they've gone through the required education, and then they have to follow the requirements here.
Mr. Chair, that's correct in the restraint section of the bill. However, in the transportation section of the bill, it makes this a shall if they're identified, and so there's no ability for the magistrate to make a determination as to whether or not they're dangerous, and they may need restraints. If a family member is identified, they have to authorize that transportation under this version of the bill. It wasn't that way in the introduced version of the bill, but under this version, there's no discretion of the magistrate to say, no, this person's too dangerous, I'm not letting them go with their dad.
Yes, the patron, if that was changed, was there?
Yeah.
I don't know that we have the original version. Probably not.
Mr. Chairman, I think that the gentleman is speaking about line 38, and that was actually in a form of the original bill. The original bill, we were trying to make sure that when you go before a magistrate, that if this is available, that it would be approved. But and I'm not sure I understood the council's question or statement, but the only way that the restraint portion could be used is if they met the requirements of DBHDS.
I think, if I understand translating between council and the senator. I think what he's saying is that because the bill says shall, if there's a family member, I'd leave the restraints out for the second. I think he's saying that it would require the family member to be used without a decision on whether or not it's dangerous. Ms. Hobbs, I see you're
Anxious to respond.
I'm sorry, Mr. Chair, I'm sorry.
Mr. Chairman, Delegate, it actually doesn't change the criteria that the magistrate must look at, which is to make sure that that it is appropriate and in a safe manner further down in that same paragraph. What it's changing is that currently, if an alternative transportation provider is identified and the magistrate considers that they are able, willing, available under those standards, the magistrate does not have to order alternative transportation. So all it's changing in this context is that if they're identified and they meet the standards under the statute that the magistrate has to determine, the magistrate then has to shall alternative transportation.
Mr. Chair, could you ask the witness to direct us to that section, because that's the issue raised by counsel?
Sure. Line 46 is what Senator Newman is pointing me to, and then also in the TDO section, separately, it is it is further down in that same paragraph.
So it's that last line and a half,
And
that the proposed alternative transportation provider is available to provide transportation, willing to provide transportation, able to provide transportation in a safe manner. Is that the?
yes, and the same is on line 178, 179, and 180 for the TDO section. Those standards haven't changed with this bill.
I don't think so, actually.
Mr. Chair, then I think it contradicts itself because you're taking the authority away from the magistrate to not authorize it when they still have to make this determination. I agree that it says when the magistrate or court deems it appropriate, but that goes back to when they originally had discretion to authorize it.
Mr. Chair. Okay, I think I understand what Ms. Hobbs is saying is that if you meet this criteria, if the magistrate determines that there is an alternative transportation provider is available, willing to provide and able to provide in a safe manner, then you shall grant it. You can't then, I think that's how I would reconcile this, so I'm satisfied.
Where the provisions are being read together, Mr. Mutinick?
I think that's a reasonable reading of it, yes.
Okay. All right. Any other questions?
No, I'm ready to move to report once you've taken any other witnesses.
All right. Is there any other questions from members of the committee?
Steve, it could be more hurtful, but I think
All right. The bill's before the committee.
that's what she said. I got to say.
Move to report.
Second.
All right. There's a motion to report and a second. Is there any debate or discussion? Okay. Hearing none, please record your vote.
She's working with it. I know, but they're trying to use existing code.
All right. Please close the roll. All right. The bill reports. Thank you. Yes, sir. All right. House Bill 873, Senator McDougall.
Thank you, Mr. Chairman. Mr. Chairman, this involves family protective orders. With the situations come up at times where the juvenile comes into court, they have been the victim or the alleged victim of a criminal offense. The emergency protective order is issued, which can be done by law enforcement or done by statute because it's an EPO with a family or abuse type situation. Then for the preliminary protective order to be requested, you have to have somebody standing in loco parentis, a family member or whoever is acting as that family member. And if the perpetrator of the criminal offense is the one in that position, there's no ability to move forward with that preliminary protective order. So that the situation could be juvenile is assaulted by parent gets bond, but the bond doesn't say no contact. The juvenile has no way to get a protective order to keep them away from the parent that just assaulted them. So this is an effort to try to, on those limited situations where the person standing in that position is staying in that position of loco parentis would be the defendant in the case. It would be the ability of Commonwealth and law enforcement to request a protective order. I think talking with Mr. Mutnick, he has a little bit of language to tighten it up, but that's where we're trying to get to, is to deal with those limited situations.
Okay, well, let's just go ahead and ask about that if you have a suggested amendment.
Mr. Chair, I think that, yeah, the intent was that this is when your next friend, who could be your next friend in a civil case, is the respondent in the protective order. So I would suggest on line 110, after the words "for the protection of such minor," and I would suggest adding, "and the respondent is a parent, guardian, or person standing in loco parentis."
That,
Is that what you want?
Mr. Chairman, yeah, that's
That's what you described. That will
contract
the bill, but
that contracts it. But that is candidly, those are the only people this are going to be able to apply to anyway. So specifying them is friendly.
Move the amendment.
Second.
All right, there's a motion and a second to move the amendment. All those in favor, say aye.
Aye.
Any opposed? All right, hearing none, the bill is amended as requested. All right, any additional questions for the patron? Or is anyone here to speak to the bill in the audience? Either for or against? There's no one online. Okay. All right. Well, we've got this new subsection in the code as described by the patron, as amended. Bills before the committee.
Second.
All right, there's a motion to report as amended and a second. Any further debate or discussion? Okay, hearing none, please record your vote.
Yes, another bill if you chose to do it.
Okay, please close the roll. The bill reports. And do you also have one other bill?
Yes, Mr. Chairman, 1264.
All right, Senate Bill 1264.
Mr. Chairman, I don't believe you saw anything like this earlier as well. This is a situation when you have a juvenile intake officer which has to process all petitions against juveniles. They frequently will defer those cases, meaning they won't send them to court. When they do the deferral process, right now, there is no ability for that intake officer to then communicate to the victim or somebody that would be subject to a no contact provision in that deferral, what has been decided. So we tried to narrow this down as well, but said that local court service unit intake officer could disclose this to the law enforcement officer, school principal where they attend school, and then we put in the rest of the language that if it's to go forward with a protection or restitution issue. So you wouldn't just normally tell the principal, but if there's supposed to be no contact and the other individuals at the school, you clearly would need to tell somebody in that position.
Okay.
So, Mr. Chairman, what frequently happens now is the victim might come back months or a year later and say, what happened? And they come to the Commonwealth's attorney, and the Commonwealth's attorney doesn't know because the information has not been disclosed from juvenile intake.
If I'm reading it correctly, though, Senator, does it still give the court service unit the choice? It says may disclose the information?
Yeah, yes, Mr. Chairman.
Is that right? So if there's something unforeseen about some reason why it shouldn't be disclosed, I guess they would be able to exercise that judgment.
Right, and Mr. Chairman, right now, they don't have any authority to disclose, or at least that's currently the practice that all court service units, can't say all in the Commonwealth, but that seems to be the practice of what they understand. They cannot disclose it, even if it's for those limited situations.
Right. Okay. Any other questions by members on the committee?
Mr. Chair.
Chairman Bell.
I don't know the answer to this. Once we put this in place, this would set both the ceiling and the floor. This would be what could be allowed, but nothing further. And it talks not just about information to the school, but to law enforcement officers, and limiting it only to that information necessary to enforce some provision. I I guess I would ask either staff or the patron, is that, I'm not aware of that being, I understand that they keep it was kind of inside the law enforcement grouping, but do they not share other information with law enforcement besides what's necessary? I mean, this seems like you can't be near this person, can't go to that place, can't do certain things for 6 months and then come back. I thought they did share more information with law enforcement. I mean, how the kid's doing. I mean, I'm just thinking sort of a more, the SRO brings the child over for something, the minor, certain things happen, there's more back and forth. I might be mistaken. If so, then we want to be careful not to restrict it, I guess.
Mr. Chairman, my understanding of this process is under diversion, so then there is no ability to share any information once that diversion has been determined. Now, before the diversion, that information, so before a petition is issued or the diversion is decided, there could be conversations at that point. But once the intake officer makes the decision to divert the case and does so, then any information regarding that diversion cannot be communicated. And that's where the problem comes, because you might have law enforcement or conversation with the school about what happened and where people are, but once the diversion is made, there can't be any further communication of this is what we decided to do. Whereas if the case went to court, the judge could order those things to occur and everybody would have a right to know. But now, once it's diverted, the victim has no right to know. The person that could be subject to protection has no ability to know as well.
Mr. Chair.
Mr. Chairman,
Delegate Watts.
follow up. Senator, to make sure I understood you, then to enforce any provision of the diversion program applies in all three instances, the law enforcement, the school, and the victim.
Mr. Chairman, yes.
Counsel, would you consider it a friendly amendment to enforce any provision of the diversion program up on line 96 so that it reads before the department or local court services may, so that it's clear that this is what we are referring to? So I'm looking at 96 after juvenile, comma, insert, to enforce any provision of the diversion program the department or local court services may disclose. Because I certainly didn't read that at the get-go. I was looking only at it applying to the third of the items.
Mr. Chairman, I'm agnostic. If you want to reverse the order of the words,
I think it would help, given the line of questioning from another much more astute individual on this panel.
Okay. Well, let's maybe while we think on that, let's hear from any testimony in the audience. Is anyone here to speak in favor of the bill? And in the course of your comments, if you wish to address some of the points that have been raised.
Good afternoon, Mr. Chairman, members of the committee. I'm James Toohey from the Department of Juvenile Justice. The department supports this bill, and I think that the concerns that Senator McDougall was mentioning are accurate. There is a situation where there could be information that needs to be known by the school principal without it being known. If the school principal doesn't know that there's a no contact order in place, there's no way to be able to help carry out that portion of the program in school.
Mr. Chair.
Okay, thank you. Delegate Bell?
Could I ask Mr. Toohey something? Mr. Toohey, so the issue I was asking was not, we keep talking in the school context, but this also would address communications between the probation officer in a diversion and law enforcement. Under current law, is that prohibited, as is between the probation officer and the school?
That's my understanding, is that when it's...
Because we're about to set some very clear limits on it, and if it's not already limited, then we're about to create limitations that don't exist. If it is, then Senator McDougall is exactly right. This will create a clear context.
Once the intake officer diverts the case, then it is in the hands of the intake officer to administer what's going to like, for example, probation, substance use treatment, things like that, and that's not shared with law enforcement.
So it could be that those provisions are commonly being violated when an officer is told, hey, we put this kid through a diversion. And is there, I mean, that seems to be
That's what I'm
your
asking. So,
understanding.
okay, I'm not asking anything complicated. This says the only time you can tell this information is as necessary to enforce any provision of the diversion program. So I understand you want to tell the school so that you can make sure that so-and-so's staying apart or so-and-so's come to class or whatever else is in the diversion program. More generally, the law enforcement might have an ongoing interaction with the minor, with his friends. How's he doing? And that's not to enforce the diversion program. It's a good law enforcement officer just seeing how people are doing. If that is already precluded, then this allows it to happen under certain circumstances. If it's not precluded, then I don't want to set up some new careful parameters for something that's already working. I want to fix what the senator is trying to fix without having some unintended consequence. That's all.
That's my understanding, is that it's already precluded.
Okay.
Okay, thank you. Anyone else? All right. Anyone online? Okay. All right. Anything else you'd like to say, Senator?
No.
All right, the bill's before the committee.
Mr. Chair, staff's had a chance to look at the wording. I don't think anybody has substantive concerns, but one way or the other will read better. I understand what Delegate Watts is getting at. Could they maybe share with us what that?
Okay, yeah, coming back to Delegate Watts' comment. All right, go ahead, Council.
Mr. Chair, we would suggest, in order to make this to read better, that the line on line 97, starting at the word as, so this would be as necessary to enforce any provision of the diversion program, that language be moved up to line 96 to come in after the word information. So it would read, the entire new section would read, notwithstanding any provision of this article, whenever an intake officer proceeds informally against a juvenile, the department or local court service unit may disclose only such information as necessary to enforce any provision of the diversion program to any law enforcement officer, school principal, where such juvenile attends school, or known victim, period. Then the rest of it would remain the same.
Is there a motion?
Second.
All right, all those in favor say aye.
Aye.
Any opposed? Okay, the bill is amended as suggested.
Next report.
All right, there's a motion to report.
Second.
And a second. Any further debate or discussion? All right, hearing none, let's record your vote. All right, please close the roll. Bill reports as amended.
Thank you, Mr. Chairman. Do I need to be present for a full committee when you take it up?
No, sir.
Thank you very much. Thank you, Mr.
Thank you.
Thank you.
Let's see. All right. Senator Deeds. Senate Bill 1292.
Thank you, Mr. Chair. 1292, I think, was similar to a House bill as it was introduced. My understanding is Senate Bill, or House Bill 2131, which from Delegate Delaney, reported out, or was identical as it was introduced. You've got a new House substitute for this bill, 1292.
All right, Council, will you please report the substitute?
Yes, Mr. Chairman, members of the committee, it should be posted on LIS now. What this substitute does is it directs DCJS to identify a suitable locality to administer the program that's described in the bill, and then directs the pilot agency, not the program itself, what the focus should be of this sex trafficking pilot program. It also removes any reference to residential care or restorative residential care within the bill, and it removes DCJS's responsibility to coordinate compliance with federal laws and then report such outcomes to the governor, attorney general, and VSCC.
All right, thank you. Is there a motion to report the substitute?
So moved.
Or, excuse me, to adopt the substitute? All right, there's a motion and a second. All those in favor say aye.
Aye.
All right, the substitute is before us.
Mr. Chair, the goal of this bill is to basically reduce the number of people that are arrested, the victims of sex trafficking being arrested, and to reduce the demand for commercial sex by going after the buyers. and to establish high-quality support for victims such as education and employment opportunities. We've worked with the advocacy organizations and the Department of Criminal Justice Services from the very beginning to try to reduce the fiscal impact of this bill. There's about $484,000 in the Senate budget for this bill right now, but I think we may have reduced the impact even more with this substitute. The substitute now directs the Department of Criminal Justice Services to identify a locality to administer a 2-year demand reduction and safe harbor for domestic minor sex trafficked youth pilot program. Right now, sex trafficking victims can face imprisonment despite being victims themselves. The substitute eliminates some of the requirements of DCJS and puts those on the pilot agency.
Mr. Chair,
Delegate Bell.
I'm going to ask Delegate Delaney, but this would appear to be the bill we already passed out unanimously and sent up to appropriations, but some things have been taken out so as to reduce the cost. Is that a fair summary?
Mr. Chair, I would say that's correct.
Okay. Mr. Chair, I'm prepared to move report and refer once we're ready.
All right. We've already heard testimony on Delegate Delaney's bill. And is there anyone that you need to have speak, Senator Deeds?
No, there's
Okay.
nobody I need.
All right.
One person on, is there,
There may be people
yeah, there's people here.
who would like to speak.
Virginia is.
Please state your name.
I'm Eleanor Gaetan from the National Center on Sexual Exploitation, based in Washington, D.C., but most of our staff lives in Virginia, including our CEO, Dawn Hawkins.
All right. Go ahead with your comments.
Thank you, Chairman Adams and distinguished members of the panel. NCOSE works across the country, and we're looking at important and landmark bills. We consider this, though it's just a pilot for 2 years in one jurisdiction, to be an extremely important bill. Virginia is one of only 4 states that still allows criminalization of youth. The others are Alaska, Hawaii, Arizona, and Virginia. There's an organization that is the expert in the nation on domestic minor sex trafficking. It's called Shared Hope International. It has given Virginia Fs 2 years in a row because of this criminalization factor. Meanwhile, we're aware of excellent programming in Roanoke. The Lampstand does very good work, and it's mentored by Wellspring Living in Georgia. And meanwhile, in Henrico County, there are very strong reverse stings focused on sex buyers, so we can finally be restricting and reducing this incidence of crime. So this bill is landmark because it brings these 2 pieces together. It's improving, it's creating protocols that the whole state can use so there isn't this patchwork of response. And it's also allowing law enforcement to really sharply focus in on the way we can reduce this. An important study of the nation found 25% of sex buyers drive 75% of the market. They're called high-frequency buyers. And when law enforcement has the knows there's political will, they can focus in on these high-frequency buyers, and we can begin reducing a market that causes tremendous harm. And the last point I will make is I have a letter for committee members. Some of the biggest organizations in the nation are based in Virginia. Polaris Project runs the hotline for human trafficking. So RAIN, Rape Abuse National Network, also based in Virginia, and RAIN is based in D.C., but most of its employees are living in Virginia. Other Virginia-based organizations, Anti-Trafficking International, Enough is Enough, Recover Hope, Wealth Management Ministries, and then organizations in D.C. with Virginia staff, World Without Exploitation, Rights for Girls, RAIN, and NCOSE. We all will stand by and help the jurisdiction that's selected make a really great protocol that can be driven across the state, and you will have a situation that's very cost-effective. And congratulations to Senator Deeds for producing a bill that really is tight. It isn't going to cost a lot, and we commit ourselves to bringing public-private partner money to support that effort, too. So let's get this done and have solutions for youth who are being further victimized when they really need services to get them out of the system and recover their lives. Thank you so much.
Thank you. Okay, I think the bill is in good shape. So is there a motion on the bill?
I move to report and refer.
All right, there's a motion to report the substitute and a second. Any further debate or discussion? Hearing none, please record your vote. Okay. Please close the roll. All right, the substitute is reported with a referral to appropriations.
Thank you, Mr. Chair. The next bill I've got is Senate Bill 1302, and I think it's identical to Delegate Ranson's 1792. We've been working for a long time to try to reduce the number of people that are sitting in emergency rooms waiting for a hospital bed on TDOs, and we've been working to try to address the underutilization of medical TDOs for intoxicated patients, people whose only problem in the emergency room is intoxication. And Senate Bill 1302 allows medical professionals to directly seek a medical TDO from a magistrate if intoxication appears to be the issue, rather than first having to find a judge. My note is that the administration supports this bill. I had the pleasure this past fall of working with some law students on the development of this bill, and I think there may be a law student here. Michael Ferguson, is he on Zoom?
Yeah, Mr.
All right,
Chair.
thank you. Delegate Bell.
So we had a version, I just want to make sure, that passed, and it was House Bill 1792.
Yes, sir.
Substantively identical. At this point, that has passed the Senate. And so while we were perfectly happy to work out the words somehow, if that's passed the Senate, I think I'm looking at the patron, I think our intention would be to go ahead and amend this to that.
That's fine.
Now, if for some reason the words are better, we can, maybe the second one passed or
amended
something.
to that. I mean, you and I talked about this. We'll work out whatever differences there are.
Okay. So, Mr. Chair, I would move to amend to conform to House Bill 1792.
All right, there's a motion and a second to conform the bill to House Bill 1792. All right, any debate on that? Okay, all those in favor say aye.
Aye.
Okay, all right, the bill as amended is before us. There is someone who wishes to speak online. I'm told, Madam Clerk.
Yes, Mr. Chair, in favor of the bill, we have Suzanne Mayo.
Ms. Mayo?
Hi, good afternoon. My name is Suzanne Mayo with the Virginia Department of Behavioral Health and Developmental Services, and we are in support of this bill.
All right, thank you. And Madam Clerk, one more.
Yes, next, Mr. Chair, we have Michael Ferguson.
Mr. Ferguson.
Thank you, Mr. Chair, members of the subcommittee. My name is Michael Ferguson. I'm a law student at the State and Local Policy Clinic at UVA School of Law. And the views I express there are my own and not those of the law school of the university. As Senator Dees mentioned, our team has had the privilege of working with him on the development of SB 1302 to help address overcrowding. And throughout the process, we've also worked with various stakeholder groups, including emergency room physicians, the Hospital and Healthcare Association, and too. So, as the delegate mentioned, the bill is identical, so I don't want any further testimony on it already. So I don't want to take up too much of your time, but I want to express my support for the bill because of its potential to address overcrowding by facilitating medical TDOs for intoxicated individuals, to reduce the burden on law enforcement officers, and to improve hospitals' ability to care for intoxicated patients by allowing them to be admitted into the hospital itself, rather than being stuck in an ER waiting room, like that. So for all those reasons, and those of you for previous information, for SB 1302. Thank you.
All right, thank you. Okay, the amended bill is before us.
Mr. Chair, I move to report the amended bill.
All right, there's a motion to report and a second. Any further debate? All right, please record your vote. All right, please close the roll. All right, the amended bill reports.
Thank you very much.
Thank you, Senator. Senator Boysko, I understand you have a timing issue. Senate Bill 1282.
This we tabled previously this year, so I will make the motion once she's.
Thank you, Chairman Adams and members of the committee. Today I present SB 1282. It's a bill that would provide the option for a person to repay all or part of their imposed fines and court costs by earning credit through community. This is the one you wanted, yeah. Okay, through community service for work while incarcerated in the Department of Corrections, prisons, or in a local or regional jail. Based on discussions with advocates and concerns I've heard expressed by members of the House, I would like to propose an amendment to the bill. and that would be reverting to the original language on line 63. Courts that want to offer community service credits in lieu of imposing fines would have the flexibility and guidance to do so. And that would be, I'm guessing the clerk has this.
Okay, you have a proposed line amendment. Is council prepared to state that? Okay. And
Mr. Chairman, members of the committee.
State it and then read it in the sentence for us.
Yes, sir. Based on what the senator has stated, it looks like on line 63, it would be unstriking may provide an option 2, and then removing the new language of shall allow. So the sentence would read like it already exists in current law. The court shall establish a program and may provide an option to any person upon whom a fine and costs have been imposed to discharge all or part of the fine or costs by earning credits for the performance of community service work or work performed while incarcerated within the subsequent Romanettes.
So just line 63.
Yes, sir.
Okay, all right. Is there a motion to adopt that amendment? Second. All right. All those in favor say aye.
Aye.
Any opposed? Okay, the bill is amended as you suggest.
Thank you, Mr. Chair. SB 1282 would provide clarity so that a request to use the community services hours to offset a court debt would be granted if the requester meets the requirements of the law and the particular court offers that option. Individuals across Virginia are leaving prison and jail setting debilitating amounts of debt incurred through fines and other costs associated with their incarceration. And frequently, people who are incarcerated have fewer prospects at the beginning of their release to earn sustained living, which would allow them to pay off those debts. Many individuals have attempted to take advantage of the benefits set forth by the existing law to use community service or work while incarcerated to offset court debt. However, because it's been a little bit unclear in the code, many eligible requests have been denied, and we believe that my bill would clarify those parameters for courts that do wish to apply them. And I ask that you advance the bill. I think I've got some people here to answer questions if you so have any questions.
All right, thank you. Are there questions from members on the committee? Okay, let's hear from the members in the audience.
Hello, my name is Maisie Osteen. I'm an attorney with the Legal Aid Justice Center. And I very much appreciate this amendment and the feedback that we got from some members of the committee. And I think that this amendment allows the parameters of the bill to be much more clear so that courts will be able to apply that framework to their requests that they're getting a lot more consistently, but still allow it to be in the court's hands of whether they decide to allow the community service to offset the debt that affects their locality and their court. We have heard from a lot of people behind the wall who have both benefited and their families have really benefited from this legislation, and those who are exactly the same situation as their cellmate and have been denied. And this would just offer more clarity and allow people to go through the system a little bit more smoothly and allow the courts to apply this law more smoothly. Thank you all. Thank you, Senator. Thank you.
Hello, Mr. Chair, members of the committee, Dominique Martin, New Virginia Majority, and for the previously stated reasons, we also support the bill.
Thank you. Anyone to speak in opposition to the bill who's in the audience?
Mr. Chair, members of the committee, my name is Nicole Whitman. I'm here on behalf of the Attorney General's Office. We are opposed to the bill for the following reasons. Number one, that these inmates are already receiving payment for the time that they spend working inside the prison, and also this is a cost to the Commonwealth. The foregoing and forgiving of court costs and fines are a cost to the Commonwealth. Additionally, in terms of potential litigation, there's a retroactive definition of the word work in this, as the code section or the bill as I have it. If I'm incorrect and there's been an amendment, I apologize. But it defines work as work performed while incarcerated, means any work done on or after July 1 of 2020 by a person confined. So that would be a source of potential litigation for the Commonwealth to defend against. So for those reasons, we would respectfully ask that you not vote for this bill, and we do oppose it.
All right, thank you. Anyone else? Okay, and is there someone online? Madam Clerk?
Yes, Mr. Chair, we have Francis Ross.
Ms. Ross? Ms. Ross, you seem to be muted. Ms. Ross, we still can't hear you.
Can you hear me now?
We can. Go ahead. Go ahead.
All right, well, I'm hoping that you can hear me.
We can hear you.
The person before me who just spoke and said that they're already being paid, the money that they receive is minus from the credit that they get, so they're not getting extra money. And the reason why it has a retroactive date of July 1st, 2020 is because that's when this original bill went into effect. And this is just common sense legislation that is much needed. Thank you.
All right, thank you. Okay, let me just ask council, this information seems familiar. I know we dealt with cognates to bills in the full committee, but the same policy objective was sought on another bill. Is that correct?
Yes, Mr. Chair. This was, as introduced or as brought to us until the amendment that was just made, this was the same bill as HB 2159 by Delegate Price, which was tabled by this committee 5-3. Obviously, the amendment today changed it slightly, but everything else in it is the same.
Okay. All right, thank you. So anything else you'd like to say, Senator?
Mr. Chair.
Mr. Chair, I've got a question for the patron.
Okay. Will you take a question first? Delegate Williams.
Mr. Chair, I'd be happy to answer a question.
Yeah, I'm curious to know how much, obviously these are court costs and fines, and I'm concerned about our court system as a whole and the subsidizing that we're having to do with it, and further subsidization, basically. And what I would like to know is, we're taking away the ability to recoup costs and fines, and I'm not hearing any information about how we're going to replace that cost to the Commonwealth.
Mr. Chair, Delegate Williams, my understanding is that the work that the individuals are doing offsets other costs that would come to the Commonwealth. So I actually don't have a FIS on this bill. So I don't have an answer for you, but there's not a fiscal impact on the bill.
Mr. Chair.
Which tells me that there's not a serious cost to the Commonwealth if we were to implement this. If it would make the committee feel more comfortable, I would entertain an amendment to make it just looking forward and remove the
Well, as you
2020.
heard me state earlier, I think, the problem, I think, is going to be on the policy objective that you have with the
Yes, sir.
committee, frankly. But is there anything else you'd like to add?
No, I thank you for considering the bill.
All right, thank you. And Delegate Herring.
Thank you, Mr. Chair. Speaking to the bill at the appropriate time.
Okay. All right, is there a motion on the bill?
I have a motion to lay the bill on the table.
Okay.
So that just cut off my ability to talk to the bill.
Okay, I thought you were going to make a motion to report.
Trying to follow
Do
a
you mind
procedure.
withdrawing your motion?
Yeah,
Okay.
thank you.
All right.
Thank you. Just speaking to the bill, and I can not understand, but I can hear the other side's concern of this policy decision that we have to make about the cost and how does the Commonwealth recoup the costs. But when we look at the fact that individuals are doing community service, and the reality is that as someone who does time, it's going to be difficult for the Commonwealth to recoup costs. They're just going to be out of a job, et cetera. So I think though, by allowing community service as a way to show responsibility, also paying back in a different method. We don't always have to think within the box of what cost is. We can look at it a different way. And so I thank the Senator for bringing this bill. Unfortunately, I realize where it will go, but thank you, Mr. Chair, for giving me the opportunity.
Mr. Chair, I have a motion.
Delegate Williams.
I move to pass by indefinitely. I'd like to speak to that.
All right.
Not speak to the motion, but argue.
Okay, there's a motion to pass by indefinitely now. And is there a second to that motion? Okay. Delegate Williams.
I think my concerns about cost to the Commonwealth are being misunderstood. What we're having here is folks do community service, quote, instead of paying fines and costs or giving credit for the fines and costs. But we don't have any money that is replacing that community service time. So my concern is that how are we going to keep paying for judges? How are we going to pay for courts? We've got cases where we got bills on our docket saying we're going to increase the cost or the payment that court-appointed counsel can receive. I've heard for people advocating for public defenders to get equitable pay. We're not able to get costs. We're not able to continue to subsidize all of these things. And to say that, folks, they can't pay while they're in jail, sure. But afterwards, when they've done their time and they want to get back up and get their feet on the ground, they should be able to pay off their debt. That's why I PBI.
All right, thank you. Delegate Watts.
Thank you, Mr. Chairman. Since this is now a debatable motion,
I
have never regarded our full judicial system to be something that is to be supported by those that are a subject of the judicial system, the full extension through corrections. So I look about how do we make up costs. We make up costs as we do as any other essential government service, and that is out of general revenue. I also would if this program was given more focus, as it currently is, as far as the responsibility while incarcerated to be focused on doing meaningful work, it aids tremendously in the rehabilitation and the possibility that the person, upon being released, has both a disciplined attitude towards work and skills that allow them then to, as you indicated, when they're on their feet. And the final thing I would point out that there are a number of public service jobs that we may find that we're going to need more than ever. I go back to the day when it was road work, cleaning up the roads. And there were rural localities in particular that absolutely didn't want to see that program go away. Well, when I look at some of the climate incidents that we're having and the necessity to whether it's filling sandbags or whether it's clearing back all of the debris that has gone into the flood, whatever it may be, I do not think that there will be a lack of meaningful work that the public needs to have done by individuals when they're incarcerated. Thank you, Mr. Chairman.
All right, thank you. Okay, the question is on the motion to pass by indefinitely. Please record your vote. All right, please close the roll, and the motion carries. Thank you, Senator Boysko.
Thank you. I have a second bill. Did you want to
Senate
hear
Bill 1159.
that? Yes, sir.
Yeah.
Thank you, Mr. Chair. This actually is a cost saver to the Commonwealth. 1159, SB 1159 would make collections and the interest on court debt both start at the same time, 180 days after release, to give formerly incarcerated people time to get back on their feet and save the state money. Currently, the law requires the court debt to be sent to collections 90 days after someone is sentenced if they haven't paid their court debt in full or started their payment plan, and the interest on the court debt starts at 180 days. The Commonwealth's attorneys may contract with collections agencies to collect outstanding debt, and in fact, collection agencies can take up to a 35% fee from collected debt. And that 35% is only offset by the 17% collection fee charged to the people who are convicted. The rest of the fee contracted to the collections agency is paid by none other than the Commonwealth of Virginia, our taxpayers. If the formerly incarcerated person is employed before the payment is expected, that person's account will not be delinquent and there would be no need to pay a collection agency. So I have some statistics. Virginia paid both private and public collection agencies a total of almost $26 million $25,959,545 and imposed almost $106 million in collection fees on people struggling to pay debt during that time. So $26 million and imposed $100 million. The fiscal impact statement indicates that it would cost the Commonwealth about just under $300,000 to reprogram the court's financial management system to implement this bill, but the one-time cost would be quickly recouped by funds saved by not paying the collection fees. I think it makes sense to have interest on debt and collection start at the same time, and I know that Delegate Williams had an issue on line 15, and if he would like, I would be open to removing the restitution from the bill, changing when the debt goes into collection from 90 to 100 days, and that is line 15, if that is his interest, trying to be responsive to the concerns that you all are raising.
All right, thank you. All right, are there any questions by members on the committee? Okay, I would just ask a question of council. Again, this policy objective, I think, was heard on a House bill. Is that correct?
Yes, Mr. Chair, this was heard, again, Delegate Price's bill, HB 1655, which was PBI'd 5-3.
All right, thank you. So, all right, are there anyone in the audience who wishes to speak to the bill?
Thank you, Mr. Chair and members of the committee. My name is Teresa Hepler. I'm a community advocate and attorney with the Legal Aid Justice Center, and I appreciate being before the committee again to clarify a few things. So this bill will actually make it easier for people to pay their outstanding debt by giving people more time to get back on their feet after dealing with the collateral consequences of a criminal conviction and incarceration. They will be in a better position to get a job, to get housing and general stability so that they can actually start making payments on their court debt. This bill would make collection start at the same time as interest. And as I had said before, but just as a reminder, interest was changed to start at 180 days when debt is delinquent for this very same reason, to give people time to get back on their feet, to actually make their payments. If collection starts before 180 days, that completely undercuts the point of the interest being changed. And the interest bill back in 2021 did have bipartisan support from this committee and the full House Courts Committee. The Judiciary Committee did strike restitution from this, so this would just be fines and fees and not restitution, which was included under Delegate Price's bill, so there is some difference. We've heard a lot from reentering folks that the 17% collection fee makes it much harder for them to pay their bills because the amount becomes so much higher. They struggle to pay it, and then they have to start prioritizing food and housing and that sort of thing and their general needs. As Senator Boysko said, between 2014 and 2022, Virginians paid over $100 million in that 17% collection fee alone. That's not the original debt amount. That's just the collection fee that was added on. And as Senator Boysko said, that 17% only offsets a portion of the cost to the state, not the entire cost. So if more people are able to pay their debt, then that should be less of a cost to the state. Thank you.
All right, thank you.
Hello again, Mr. Chair, members of the committee, Dominic Martin, New Virginia Majority, and again, we support the bill also for the previously stated reasons.
Okay, anyone to speak in opposition to the bill? All right. Okay, anything else you'd like to say, Senator?
I think my witnesses explained it perfectly. Again, this could end up saving the Commonwealth money, and I think it's the right thing to do.
Okay. All right, the bill is before the committee.
Mr. Chair, I've got a question for the patron. Could you possibly go over the percentages again with the cost-saving argument?
Yep, let me just get it open. So currently, the collections agencies can take 35%. They can charge 35% on the collected debt. There is a 17% that is charged to people. The rest of that 35% is the Commonwealth eats that. So it's a pretty big pot of money. And the argument here is that if we allow the collection and the the interest at the same time, we would end up saving money because there'd be fewer people who would be, behind on their payments if we give them the full 180 days.
Mr. Chair.
Delegate Williams.
So what would you say about the folks who enter into a payment plan for $50 a month, and this happens very regularly,
Okay.
and they don't pay that? I mean,
Mr. Chair, Delegate Williams, my understanding is that this is specifically for people who don't have a payment plan started. So this isn't addressing that. If they've already got a payment plan and they're not making good on it, then they need to be held responsible. This is for, as I understand, the current law says that if they haven't paid their court debt in full or have not started a payment plan, the interest starts at 180 days. And my proposal here says that if we put the two together, then we would be able to do better.
okay, Mr. Chair.
Delegate Williams.
So they didn't get a payment plan even though it's available, or they failed to make their payments. Are really the only two options for somebody to fall into this collection.
And Mr. Chair, Delegate Williams, again, the Commonwealth is taking up half of the 35% fee.
Mr. Chair.
Delegate Williams.
That doesn't compute, because if you look at the 58-13958, it talks about the allowance for additional fees on top of that. So my question for the patron is, how much have we been able to collect rather than pay out, based on your argument that the Commonwealth is paying the majority of the difference?
Mr. Chair, I'm going to phone a friend who is an expert in this area.
All right, go ahead.
Thank you, Mr. Chair and Delegate Williams. So right now, there is a grace period under current law for interest and for collections. Collections, the grace period is 90 days. We're just looking to make that grace period 180 days to match interest. So they're still going to have to pay their court costs. Like, no matter what. If they are late 180 days, they will still have to pay it. Collections will start.
Okay.
Mr. Chair,
Delegate
a
Williams.
question for the patron.
All right, another question.
You understand what I'm saying? They've taken 3 months, they haven't got a payment plan, and they haven't made good on their payment plan, and now you want to give them 6 months to do something they could have done the week after they got out of jail.
Mr. Chair, Delegate Williams, I would just question if you have talked to very many people who have been recently incarcerated, because it's very difficult for a lot of them to get everything on their, themselves on their feet. Sometimes they go through multiple applications for work, and they find that they continue to run against a brick wall. Sometimes they have no family, no place to live. We want people to be successful when they get out of being incarcerated, to become productive, tax-paying citizens. Giving them a little bit more grace in this will not only save the Commonwealth some money, but would also give them a better chance of getting on their feet.
Mr. Chair.
Delegate Ranson's up.
Okay. Oh, she just yielded to me. I have a motion to pass by indefinitely. I'd like to speak to the argument.
All right, did you have anything else, Delegate Ranson? Okay. All right, so there's a motion to pass by. Is there a second?
Second.
All right.
I'd
Delegate
like to be
Williams.
clear that I take offense to being asked to spend more time with people who have been recently incarcerating, as somebody who has actively worked as a court-appointed attorney for 8 years. And my concern with this is that we're kicking the can further down the road. You've already heard me discuss and speak about our court system and how we're having to subsidize the entire thing at this point. And I don't feel comfortable allowing someone else to continue to not pay their debt to the Commonwealth when we've given them 3 months, we've given them a payment plan, we've given them a number of options, and they're clearly failing to recognize or access any of those things.
All right. Any further debate? Delegate Herring.
Thank you. I'll just be brief. I mean, I think clearly, because ever since I've been here, we've been talking about this. And I would urge us to be a little bit more open-minded. What we're doing obviously is not working. I have seen instances, this is not my area of practice, but I have seen instances where a payment plan is not always offered. So we can't just assume that there's a payment plan. And this is something that we always talk about. And I think that we need, again, like I said earlier today on the House floor, you really need to think about putting ourselves in other people's shoes, and not to you, Delegate Williams, because I realize that you represent individuals and defendants, but figure out what it is that we're doing wrong or how we can make it better. And it's not just that these individuals are lazy, don't want to pay, et cetera, because I feel that sometimes we're caught in that mindset as a collective. And we've got to do something a little bit different and think outside the box. Thank you, Mr. Chair.
All right, thank you. Okay, the question is on the motion to pass by indefinitely. Please record your vote. All right, please close the roll. And the motion carries 5-3.
Thank you so much.
Senator Norman, Senate Bill 1413.
Good afternoon, Mr. Chairman, ladies and gentlemen of the committee, and on behalf of One Perspective from the Senate, I appreciate you giving the senators the opportunity to present their bills. Having said that, I have Senate Bill 1031, I believe, sir.
All right. Senate Bill 1031?
Is that the wrong one?
I have 1413.
No,
It's the only one I see.
1413. We can do that one too. Thank you very much. For the past couple of years, Mr. Chairman, there's been discussion about various approaches modifying expungement, and there have been some broad, rather comprehensive proposals. This is a very narrow situation that was brought to my attention by a number of municipalities. And while it's fairly short, about 5 or 6 lines, it is very detailed. And what it provides is that if you have a civil cause of action that is pending, i.e. a lawsuit that has arisen out of a criminal matter, and as the municipalities are trying to defend it on the civil case, that there may be records which have been expunged incidental to the criminal case, which are highly relevant to the underlying civil case. In some of these cases, frankly, municipalities are confronted with the coming out of civil disobedience, and sometimes witnesses are challenged. And so what this provides is a very narrow situation. One, that a motion may be filed with the court in which the civil action is pending, and that the court may consider it, and the court would have to make a determination that for good cause shown, those requested police reports or investigation reports are ordered to be released only for that situation. And that's pretty much the case, is that some of the municipalities are finding it challenging to get the investigation reports that they need because they may have been expunged for a modest underlying criminal case, but yet a significant civil case arises out of it. So it would be released only from that, for that purpose, and with the concurrence of the court after conducting a hearing, and then it would be returned to an expunged situation.
Thank you. It does seem to be a very narrow situation, as you say. Questions for the patron?
Mr. Chairman.
Delegate Bell.
Senator, I'm trying to visualize, and I think, so in some cases, it would be the, let's just call him the petitioner for the expungement who was him or herself bringing the matter forward. And I could visualize that the locality needs to defend itself from a motion brought by the person who petitioned for their own records. It seems like there would be a much smaller category, but an occasional circumstance where I got an expungement and Mr. Munich was the one that filed suit. And so I'm not doing anything to open up my records to this issue, but they would be important to the lawsuit. Would there be a provision that the court would be able to seal those or otherwise keep them limited to the purposes of the litigation? In other words, I get that if he petitioned and he then brings the lawsuit, that's kind of his choice, and the city needs to defend itself from him, and that would surely be the majority of this tiny category. Is there some mechanism whereby if it was some, so to speak, disinterested third party, that they would be, that the records could be protected or otherwise?
Mr. Chairman, actually, I had contemplated that, and I have a note down here that I just scribbled sitting there, which were two notes. One is an RMD, which some localities are using. I wasn't familiar with it where I practice, but that's a restricted material distribution on it. But I think more in a line which we may be conversant with is a protective order as it relates to the documents. And I don't have any objection to it, to doing that. It is not trying to besmirch anybody, but sometimes on these cases where an individual who's charged of a criminal offense for whatever reason, lack of witnesses, whatever, is dismissed, and then they immediately turn around and file a civil cause of action against the city or the law enforcement officers. And there's difficulty getting to the investigation notes because they have been sealed as part of the expungement. So I don't have a problem if the committee thinks that a protective order or some kind of restrictive language would be appropriate.
I mean, I'd ask counsel, I don't do this kind of work, but if it's generally available, then putting it here actually raises more problems than it saves.
Mr. Chair, it's not actually generally available. There's only really two exceptions to being able to get it. And I think what Senator Norman was talking about was the restricted dissemination material from discovery motions, which is just, it has nothing to do with this. It's just another option to say that you could restrict it. And I think that was what I was going to point out as well, is there's no bar against further dissemination of this material once it's been released. And so I think there is language that could be put together to make it very narrow to just this case, and possibly to say in an action for damages filed by the petitioner in the expungement, and that way it keeps it to that very narrow.
Mr. Chairman,
I'm not saying you might not need my records, so I understand the need to have them. I'm just thinking that if I didn't bring it back, it'd be nice to have a way to get a protective order put in place if that was what you're trying to do. But if it's not a friendly amendment, I'll leave it alone. That could be a get your own bill kind of question.
Mr. Chairman, Delegate Bell, having been involved in some of these cases, I could understand why the immediate reaction is, hey, I don't want you to have the expunged record. And it's certainly not going to do anything to vitiate the previous finding of not guilty on the criminal offense, but it very well may disclose relevant witnesses in investigation that is not otherwise available, because now I do a lot of criminal work, as some of you all do, and if I try to file a motion for discovery and the response I get back from the police department is, well, we don't have any records because it's all been sealed as a result of an expungement, you find yourself in a very difficult situation.
Mr. Chair, I think that may be a different bill, so
Okay.
I think this is fine. I'm going to.
All right, good. Because there's nothing prohibiting in the bill the court from taking that kind of action if requested.
No, sir. And
it's
I
only
think
after it's good cause shown.
Excuse me. And I do think that the court, in the interest of balancing justice, has the latitude to put whatever constraints they may on it as they're hearing the motion. And that's why I actually included the language to have a motion before the court for good cause shown so that there would be some judicial oversight and constraint consistent with what they think is in the best interest.
All right, thank you. Any other questions? Okay, anyone in the audience who wishes to speak in favor of the bill? Oh, you do have someone? Oh.
Yes, Mr. Chair. Hi, my name is Maggie Cleary. I'm the Deputy Secretary of Public Safety. The administration supports this bill. Thank you.
Bonjour.
Hello. Good afternoon, Mr. Chairman. I'm Jerry Wilson with the City of Newport News, and we support the bill.
All right, thank you. Anyone opposed? All right.
Second.
All right, there's a motion to report and a second. Any further debate or discussion? Hearing none, please record your vote. All right, please close the roll. The bill reports 6-2.
Thank you for your courtesies. Have a nice afternoon.
Thank you, sir. Okay, who was next? I'm sorry. Senator Favola, Senate Bill 852.
Good afternoon. So, Mr. Chairman, Senate Bill 852 is very simple, very straightforward. What it does is it would protect menstrual health data from a search warrant. And menstrual health data that may be stored on an electronic device or any digital information simply would not be available through the search warrant process. That's it. That's my bill. It's intended to keep very personal health data personal. So I may have a few speakers, but I doubt you have any questions in understanding the bill. But
I'm afraid Delegate Williams has a question.
Don't make me sound terrible.
it did pass the Senate 31-9.
I was just curious, question for the patron. Okay. I was curious about HIPAA and the protections that are in place under HIPAA, and I saw counsel shake his head. Am I off? Doesn't apply to, so it's a, can you just say that louder?
Yeah.
Yes, Mr. Chair. I don't think HIPAA, or at least in my research, HIPAA doesn't apply to these third-party apps
correct.
because they're not related to health care. They're just apps where information is stored.
Okay. Thank you.
Mr. Chairman, I have a question for the patron.
Delegate Ranson.
Yes.
So what age group are these apps targeting?
I don't know what age group they're targeting. I don't have an answer to that.
Teens? We don't know what age group they're targeting? Okay.
I cannot answer that. Anybody might have access to an app. I just can't answer that question.
Okay. All right, is there anyone here who wishes to speak in favor of the bill?
Good afternoon, Mr. Chairman and subcommittee members. My name is Lexi White. I'm the policy director with Repro Rising Virginia. This is critical legislation because it protects the privacy and confidentiality of individuals' menstrual health information. This legislation recognizes the sensitive and personal nature of menstrual health information and ensures that individuals can access and use menstrual health related products, services, and apps without fear of their information being compromised. By protecting menstrual health data, Senate Bill 852 empowers individuals to manage their health with confidence and privacy, and we see this as a critical tenet to achieving reproductive equity here in Virginia. Thank you.
All right, thank you. Anyone to speak in opposition?
Yes, Mr. Chair. Hello, my name is Maggie Cleary. I'm the Deputy Secretary of Public Safety and Homeland Security. While the administration understands the importance of individuals' privacy, we do oppose this bill. And that's because this bill would be the very first of its kind that I am aware of in Virginia or anywhere that would set a limit on what search warrants can do and what search warrants can be sent out for and what they can return. Currently, any health information or any app information is available via search warrant. We believe that that should continue to be the case, and if this bill is reported, the administration's concern is that this would ultimately open the door to put further limits on search warrants down the road, and that would be incredibly problematic from a criminal law or really any legal standpoint. So for that reason, we do oppose this bill. Thank you.
I would just conclude by saying there's very little information that is as personal and private as your menstrual data. So I would ask that we protect privacy.
Okay, thank you very much. Okay, the bill is before the committee. All right, there's a motion to report and a second, and there's a substitute motion. Please state it.
Substitute motion to lay Senate Bill 852 on the table.
All right, and that has a second. So there's a motion to table with a second. That's non-debatable. Please record your vote on the motion. the roll. The motion to table carries 5-3.
Thank you.
Thank you. Okay. Oh, Senator Hashmi. Senate Bill 929.
Thank you, Mr. Chair and members of the committee. Senate Bill 929 seeks to address an issue that has emerged in many states, including Virginia. And so the background here is that the federal immigration law allows for the deportation of legal permanent residents and visa holders for the conviction of a crime of moral turpitude for which a sentence of 1 year or longer may be imposed. So because the Virginia Code defines Class 1 misdemeanors as punishable by up to 12 months in jail, a conviction of a misdemeanor can lead to deportation. So what we are seeking to do is to change the sentence from 12 months or 365 days to 364 days. That 1 day can make the difference for so many families and individuals who may be caught within the system. So deportation does not actually even depend on the actual sentence that's assigned to a person, but it is the potentiality of a sentence that a judge could assign to the individual. Because Virginia's Class 1 misdemeanor sentencing overlaps by 1 day with the federal government's category, any immigrant convicted of a Class 1 misdemeanor could be deported. So this particular bill does not affect any immigrants who are here without deportation. Undocumented immigrants would not be protected by this change. And similarly, other offenses that are for which an individual is convicted and is on permanent resident or visa status could be deported. Offenses such as aggravated felonies, controlled substance crimes, firearm crimes, and crimes of domestic violence. All of these are dealt with in a different section, in different sections of the code, and so they would still be grounds for deportation. It's simply the crime of moral turpitude that this would address.
All right, thank you. Are there any questions for the patron? I guess I would ask a question. I mean, it's very intentionally a bill to circumvent the federal law that explicitly says Class 1 misdemeanors, correct?
I wouldn't say that it's circumventing so much as addressing an issue that has arisen now because of federal law. So because of federal law indicates that any sentence that is 12 months or longer is then punishable by deportation. It kind of swept into our system individuals who were convicted for Class 1 misdemeanors on the issues of moral turpitude. So other states have faced this same concern. Other states have sought to address it, including Nevada, Washington, New York, Colorado, and Utah. They've all changed their misdemeanor sentencing to have a maximum penalty of 364 days in order to address this issue.
All right, is there anyone here to speak in favor of the bill?
Mr. Chair, members of the subcommittee, Christian Martinez, I'm the Advocacy Specialist of Acosta. We thank the patron for bringing up this bill. As she said, 1 day does indeed make a difference. This goes to the individual and their family, and for those reasons that she was stating earlier, we do ask you to please support this bill. Thank you.
All right, thank you.
Hello again, Mr. Chair, members of the committee, Dominic Martin, New Virginia Majority, and again, as the patron stated, this is just meant to clean up something that has swept up more people than probably intended, and so we would hope that you would support the bill. Thank you.
Thank you. All right, anyone here to speak in opposition to the bill?
Good afternoon, Mr. Chair, subcommittee members. Brandon Arbleski, Special Assistant to the Attorney General. The Attorney General respectfully opposes the bill. This is an issue that should be left to the U.S. Congress. Thank you.
All right, thank you. Anyone else? Okay, Delegate Williams.
I have a motion when appropriate.
Okay, is there anything else you'd like to say in closing, Senator?
I would just add that this did pass out of the Senate, and I'm afraid we did not hear from the Attorney General's office during our discussion in the Senate. We would have sought to address some of those concerns.
All right, thank you. Okay, Delegate Williams, you have a motion?
Yeah, I move to pass by indefinitely.
All right, there's a motion to pass by indefinitely and a second. Is there any debate on the motion?
I'd like to debate, Judge. I'd like to debate, Mr. Chair. Go ahead.
You'd like to debate?
Yeah. Would you like me to go ahead?
Go ahead.
Okay, so my concern here is that we're intentionally altering our language to deal with a federal issue. And specifically, I heard somebody say, the wrong people are getting swept up in this, but this is punishing people who are breaking the law illegally and while they're in the country illegally. And so this is appropriate. If they're breaking the law, then they don't need to be here and continue to break the law. So the deportation issue can go further and handle that, but that's got its own issues, as we know. So I vote to pass by indefinitely. I hope you will too.
Thank you, Mr. Chairman. If I could just correct a comment made by the delegate. This does not impact anyone who is in here, in this country illegally. It does not affect any undocumented immigrants. They would not be protected by this change. This particular bill impacts only those who are green card holders, who are here on legal status, or who have visas. And as we know, individuals who are permanent residents have families who are citizens in this country. So you may have someone who is a permanent resident who has children who are citizens, or a spouse who is a citizen. So this particular concern impacts families that are typically stable, that are living here in Virginia, and that have established residency here.
Yeah, right. So just adding 15 seconds, associating myself with the senator's comments. And the punishment for whatever happened that is being charged as a crime to deportation goes far beyond what the intent is of our law to punish appropriately. And we have the appropriate punishment set out for each criminal act. But deportation goes far, far beyond that for the individual and the families involved.
Mr. Chair.
Delegate Williams.
I feel like something I said was mischaracterized.
Okay, go ahead.
This does impact people who are in the country illegally, because if they're in the country illegally and they get arrested for a Class 1 misdemeanor, then there are organizations out there that are not choosing to hold them and not choosing to deport them. They are choosing to release them and let them go do whatever they want. So this does impact people here illegally, but it also impacts the folks that the senator has pointed out. And I want that to be clear for the record.
All right, the question is on the motion to pass by indefinitely. All right, please close the roll. And the motion carries.
Thank you, Mr.
Senator.
Chair.
Senator Edwards, I guess. Here you've got two bills, Senate Bill 939 and 940.
Okay, thank you, Mr. Chairman, members of the committee.
Okay.
939 is a bill that builds on what's already in the code. When it comes to the court's sentencing, the trial court has to set on the record of the case a written explanation of any departure from the discretionary sentencing guidelines. What this does, if a defendant objects to the calculation of the discretionary sentencing guidelines, it could be reviewed on appeal, and the judge could be required to re-sentence the defendant, or the defendant could have some other post-conviction release. The reason for this is there are times when the judges do not explain themselves, and they say way above the guidelines. And we as a body, when we evaluate judges for re-election, one of the things we look at is, are they within the guidelines? And they don't have to be within the guidelines, but they ought to explain themselves at least if they're not above the if they're too far above the guidelines. I know situations where a judge, now this is when we had jury sentencing, the jury recommended 10 years and the guidelines were like 3 years, and the judge went ahead and gave the person 10 years without any explanation. And right now, at least it would give you some opportunity to have the appellate court look at it to see whether or not the calculation was correct and whether or not there was an adequate explanation for what the judge did. So that's what this does. It follows up what we're doing is to evaluate judges themselves, and this would give us a little more ability to say, well, the judge has been was over the guidelines too often, and the appellate court said so. That gives us a little more explanation as to why this judge should or should not continue as a judge. That's basically what it does.
All right, thank you. Any questions for the patron? All right, anyone here to speak in favor of the bill or in opposition?
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth's Attorney for the City of Williamsburg and James City County. Virginia Association of Commonwealth Attorneys are in opposition to this bill. Guidelines were not intended for this. The guidelines were intended to educate the judge on what other judges throughout the Commonwealth are doing on cases that are similar in stature. And they were intended for the General Assembly to be educated on the performance on judges. They were not intended to be a mandatory requirement or mandatory on the sentence that they are to impose. The language of it has to be adequately explained. I have not been able to find any standard that would be similar to that. I don't know what adequate explanation would mean. I know that the lines for the judge on the guidelines, I think there's 2 lines there for them to provide some explanation. I don't know whether an adequate explanation takes 2 lines, 4 lines. I don't know what adequate means, and so therefore we are inviting cases to come back, but even then still no explanation as to what adequate explanation would be. In addition, we are now allowing for a case to come back to our courts, even if the sentence is within the guidelines, if they want to argue about the calculations that were done. Say they're 3 points off, there's nothing that would say that case doesn't come back to our courts for sentencing, even if the judge was within the guidelines. This opening up the guidelines to this level of micromanagement by the Court of Appeals with 0 guidance as to what standard they should use is going to be a tremendous amount of work as we basically go through sentencing hearings over and over again until it's been adequately explained.
Okay, thank you.
Mr. Chair, committee members, Brandon Robleski, Special Assistant to the Attorney General. For the reason previously stated, the Attorney General does oppose the bill. I'd also say that calculating guidelines is a matter of simply adding up points. It would be a relatively unusual appellate error to assign that the points were added up incorrectly. So for those reasons, we oppose the bill.
Mr. Chair, Maggie Cleary, Deputy Secretary of Public Safety and Homeland Security. For the reasons stated, we just want to echo the sentiments that were so eloquently put by the Commonwealth Attorney Services Council, and we oppose this bill. Thank you.
All right.
Wrap it up. As a member of the Sentencing Commission myself, what the Sentencing Commission does is take the data. That's basically what it does. And all this does is have the judge make sure the judge explains himself or herself. And if not, then if the appellate court believes it's gone above, it's not properly calculated and not properly explained, send it back or give the defendant the right to have some other post-conviction relief. That's all it does.
It is true, though, that a judge's compliance with the sentencing guidelines is already reviewed by this body, correct?
When it comes to up for re-election, that's true.
Mm-hmm.
That's all it does. And what this does, it gives us a little more information. Like, why did the judge go well above the guidelines? And if the judge has a good explanation, so be it. If not, then gives us a chance to look at the judge again. But this gives a little more data when it comes to the appellate courts saying, I think the judge overdid it in this case.
All right, Delegate Williams.
I have a motion when appropriate.
Question before
Okay, Delegate Watts has one
If
other
I could
question.
just have a question. Up on line 1819, it says that the court shall state for the record that such review and consideration have been accomplished and shall make the completed worksheet a part of the record of the case and open for inspection. Completed worksheet. Does that include not just the calculation, but something written in the box as far as what the sentence, the judge determined the sentence to be?
Well, currently...
Counsel first, thank you.
Mr. Chair, Delegate Watts, yes, you can, in any circuit court case where there's been sentencing on a felony, you can see all of the worksheets, sections A, B, C, and any additional, plus the written explanation box.
And it has been regarded that completed worksheet, something has to be in that box.
Only if they deviate from the guidelines.
If they deviate, thank you.
Okay. All right, Don Williams, you have a motion?
Yeah, I move to pass by indefinitely, speaking to the motion when appropriate. I would echo what the Commonwealth's attorney said, though specifically the phrase adequately explain. I think that we're opening ourselves to a gigantic can of worms if we pass this bill forward, and I'd ask that it be passed by indefinitely.
I'm speaking against the move to pass by indefinitely. It is possible that maybe the word adequately could be stricken. But the point is that it's saying that above you're supposed to have a completed worksheet. If you deviate, the completed worksheet is supposed to have a reason put in there. And if it does not, that is really not acceptable to both our review, but most importantly of the Sentencing Commission. There are reasons why there may be deviations, and those reasons may evolve over time, or they may be regional as to why certain circumstances are regarded as they are. So I regard not requiring this and not making that part of the reason for appeal goes against what the intent is of our advisory sentencing guidelines and our ability to shape them appropriately.
Question is on the motion to pass by indefinitely. All right, please close the roll. The motion carries 5-3.
Okay, thank you, Mr. Chairman. The other bill I have is Senate Bill 940. This has to do with court-appointed attorneys. There's a distinction between public defender's offices, which we have, but we don't have enough of them, and court-appointed attorneys, which are appointed by the court to handle certain cases. Now, to give an example, in Roanoke City, we have the public defender's office. In Roanoke County and in Salem, we don't have a public defender's office. So therefore, all the judges that represent indigents are court-appointed. And the fees haven't been changed since I don't know when. And currently, in the district court, the current statutory cap is $120. In certain cases, you can get a waiver a little bit more. And the circuit, that's in the district court. In the circuit court, it's $1,235. In case you get a little additional waiver for more, like $850. But the point is, it had not changed since I don't know when. And the people who pay this are the defendants, as you've already heard. They're the ones that end up paying the court-appointed attorneys. And so my bill is to increase the fee for court-appointed attorneys to make it more adequate, and you have more people willing to do it as well. And so that's all it does. Now, if there is an impact, it's not in Senate budget, and I don't think it's in the House budget, and the impact is $50,000 or something like that, but it could be reduced. It doesn't have to be as much as it is. So that's the bill. You make sure the defendants are given attorneys who are qualified. Careful. And also are willing to do this kind of work.
Yeah. I mean, do you even know when is the last time that has been.
I think since the beginning of 1900 or something. I don't know, seriously.
Might be.
The Supreme Court, in 1963 says everybody's entitled to have an attorney. Mm-hmm. That doesn't mean the attorney's going to get paid much. In fact, most people won't do it, but some people are willing
according
to do
to counsel, it was last century, you could say.
Something like that.
2000.
I really don't know when. It's been forever.
Okay, Delegate Williams?
Yeah, question for the patron.
Go ahead.
It was my understanding that I heard you say that the defendants were paying these fees, and so this would not be a fiscal impact on the Commonwealth. It would be an increase in payments for the defendants to pay back.
I think if they're convicted, they have to pay it back, but the state's got to pay it up front, and then the defendant would have to pay it back. So I don't know how much is paid back. I really don't know. So I just want to make sure we have attorneys who are willing and also capable of doing the job on a regular basis. That's the problem. We don't have enough people willing to do it on a regular basis as a general matter.
Okay. Anyone who wishes to speak in favor of this bill? Okay.
Good afternoon again. Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, here speaking on behalf of the Virginia Association of Commonwealth Attorneys. We are in favor of this legislation. Mr. Chairman, in many smaller jurisdictions, we are losing court-appointed attorneys. The lists are getting smaller and smaller because the work is growing and growing, but the fee isn't. I am sensitive of the fact that if a defendant is convicted, they will be paying more with these fees, but this is something that is desperately needed if we're going to continue to be able to provide the outstanding indigent defense that we do. And so the prosecutors are in favor of it.
All right, thank you.
Mr. Chair, committee members, Brandon Robleski for the Attorney General. For the same reasons, the Attorney General supports the bill. Thank you.
All right, thank you. Anyone? Looks like there's someone online.
Yes, Mr. Chair, we have T. Mallory.
All right, Ms. Mallory.
Good morning, Mr. Chair, members of the committee. The Virginia NAACP supports the bill. Thank you.
Okay. All right, so the bill is before the committee.
Mr. Chair,
Chairman Bell.
may I ask either the patron or council if this were to pass, how we would then be compared to other states? In other words, I understand the current rate, but this is a different rate.
I've not done that analysis. I really don't know.
Mr. Chair, I can tell you that we would still remain pretty close to the bottom of what all states would pay for those. We are right now, I think, the lowest, what we pay, at least for misdemeanors, court-appointed attorneys.
I would suggest we don't really want to be the lowest.
Okay. We can move to report.
Okay, and of course, this does have to be referred to appropriations if it reports favorably. Is there a motion?
So moved.
All right, there's a motion and a second to report and refer the bill to appropriations. Is there any discussion? All right, hearing none, please record your vote. Okay, please close the roll. Bill reports and refer to appropriations 7-1. Okay.
Thank you, Mr. Chairman.
Thank you.
And members of the committee.
Mr. Chair, Senator Donovan is here.
Senator Donovan, I apologize for your long wait.
Hers is easy. I can tell you.
That's okay, Mr. Chairman. I got to the other subcommittee and back, so I'm counting my blessings. Mr. Chairman, I have Senate Bill 1436 before you now. You saw a version of this in House Bill 1416. This is the version that you see before you now is one that has gained consensus and actually has consensus of the House patron as well. And this speaks to returning to the code an opportunity that includes due process, that allows the testing of somebody who is in the court process and is possibly or has been convicted of a sexual assault where there were bodily fluids that were involved, even if there were just bodily fluids involved, so that the victim has the opportunity to determine what their starting point is for going forward? Do they need to take prophylactic medication? And really just an awareness so that they're not victimized again by their uncertainty and insecurity. So, Mr. Chairman, this is pretty standard of care in the medical arena. If you have a stick and you have an exposure, you have the opportunity to find out the baseline labs on the individual. And so I hope it'll be the pleasure of the committee to accept this version.
All right, thank you. And if you could just identify, you said that the House version of this is a little bit different, but you've discussed it. You anticipate.
I think that one of the big issues that was included in this was some of the due process language. There was also an update. Again, the legal aspect of this is not my expertise. It's more of the medical side. But I think also there was language that needed to be updated. At first, the first move was to pull the old code that had been stricken in 2020. And when that was reinstituted, it was noted that there were some flaws, particularly in the case of juveniles. So language was reworked from there, and then there was duplicate due process language added in under the juvenile section. And then the reference to what we were going to count as sexually transmitted infections and the reference to the board. And I think those are most of the changes, but I do have somebody here that can speak to the legal aspects if you desire.
Just to adopt the Senate
Okay.
version without change.
All right, any other questions for the patron? Anyone here to speak in favor of the bill?
Mr. Chair, committee members, the Attorney General does support the bill to return this right to victims, make Virginia, again, one of the 37 states that does afford this right to victims with the due process protections in place. Thank you.
Good afternoon, Mr. Chairman. Nathan Green, Commonwealth Attorney for the City of Williamsburg and James City County, speaking on behalf of the Virginia Association of Commonwealth Attorneys. We do support the bill as well.
Okay, and it's my understanding the House patron is not requesting your bill be conformed, as you say. So, all right, is there a motion?
Move to report.
Second.
All right, there's a motion to report and a second for the bill as presented. Any discussion? Hearing none, please record your vote.
There he is. Good timing.
All right, please close the roll. The bill reports 8-0.
Thank you, Mr. Chairman.
Thank you. And Senator Obenchain. Perfect timing. You have 3 bills before the committee.
I don't have the numbers. I apologize.
All right. Is there one you want to pull up or want to discuss first? All right. We have the first one numerically is SB 1223, Vulnerable Adults Financial Exploitation.
Mr. Chairman, members of the committee, this is a recommendation of VCJC dealing with venue in these financial exploitation cases. This is intended to make venue consistent in these cases with other financial crime venue statutes, particularly the credit card fraud statute. It provides that venue for these cases can be, in addition to the existing venue provisions, the location where the vulnerable adult resides or resided at the time of the offense, and the location where the vulnerable adult sustained the financial loss as a result of the offense. A couple of reasons. One is the hardship. Number 2 is the fact that these crimes are taking place from remote locations. They don't always take place at the front door of the vulnerable adult. And when it takes place, when somebody perpetrates one of these crimes from D.C. or Pennsylvania or Fairfax or Arlington, and the victim is in Richmond or Suffolk or Petersburg, it makes sense to have the case venued in the location where the loss occurred or where the victim resides or resided.
All right, thank you. All right, any questions for the patron?
Mr. Chair.
Delegate Williams.
I have a question for counsel.
All right, go ahead.
Counsel. This is very similar to what we do for jurisdiction and venue on identity theft as well, I believe. Am I correct?
Mr. Chair, this actually, the 2 new the old venue statute is what we do in identity theft. The two new ones are similar to credit card offenses. Yeah. That's where we use the victim's residence, and financial loss. And then in forgery offenses, we use the financial loss location as well.
Any other questions? All right, anyone wish to speak to the bill?
Nathan Green, Commonwealth Attorney, City of Williamsburg, James City County, here speaking on behalf of Virginia Association of Commonwealth Attorneys. We do support the bill. Happy to answer any questions you may have.
All right, thank you.
Mr. Chair, committee members, Brandon Robleski from the Attorney General's office. The Attorney General does support the bill as well. Ask the committee to report. Thank you.
All right. And the bill does come as the recommendation of the Criminal Justice Conference, which is made up of prosecutors and defense counsel. All right. The bill's before the committee.
Move to report.
All right, there's a motion to report and a second. Any discussion? All right, hearing none, please record your vote. All right, please close the roll. The bill reports.
Mr. Chairman, members of the committee, the second bill I have is the marijuana advertising bill, and perhaps clerk or counsel can tell me the number of that bill.
That's 1233.
1233. My understanding is that it's likely the desire of the committee to conform this to the version, the House version of this. Delegate Wilt had a version that I think you all did some significant surgery to, and I certainly like mine, but I understand the will of the committee.
Mr. Chair.
Delegate Bell.
You may recall this was the one where we were not sure where this was headed, and so we took most of the bill out so that the process could continue. And so at the appropriate time, I'd like to move to substitute the bill as it left the committee, because if you recall, we did a second step.
All right, the patrons indicated he expected that. You want to make that motion?
I do. I move to conform it to the Wilt bill.
Do we have the number?
2428.
All right, so the motion is to conform Senate Bill 1233 to House Bill
2428.
2428. Is there a second?
Second.
All right. Any further discussion on that? All those in favor say aye.
Aye.
Any opposed? All right, hearing none. Substitute is adopted. Senator, anything else? Go for it.
I think as it stands now, it is a total ban on advertising of all marijuana products. My bill, as introduced, and Delegate Wilt's as introduced, sought to import essentially the restrictions that we already imposed for alcohol advertising in hopes of limiting the advertising of these products to minors. And so I understand the desire of the committee.
All right. So maybe a conference report.
Move to report.
Second.
Do we need to refer?
All right.
I don't think so.
No. Okay. There's a motion to report the substitute or the conform bill. Is that right to say substitute? Okay. And a second. All those, any discussion? Okay. Hearing none, please record your vote. All right. Please close the roll. Okay. The substitute reports 8-0.
And, Mr. Chairman, finally, bill dealing with post-release supervision and parole, the process for handling violators of the terms of release. My understanding is that the committee took up Delegate Wampler's bill 2230, and that it is likely the desire of the committee to conform this to the version that Delegate Wampler got out of the House, which is fine with me. This is something that we've worked on together with the Attorney General's office and other stakeholders, and I am advised that this process, or that the version that came out of the House is a version that that the stakeholders I've been working with are very comfortable with, and it's intended to streamline and conform the process for handling violations so that there isn't a disparity in treatment of these cases.
Okay, so this is Senate Bill 1245. And are there any thoughts by members on the committee about the House version and the anticipated motion to conform?
Mr. Chair, you might recall that Wampler had two bills, and this was the one that we passed out, making the first bill unnecessary. So I would move to conform this measure to House Bill 2226 from Delegate Wampler. I'm sorry, I apologize. 2230 from Delegate Wampler, which passed the committee and ultimately passed the House, I think.
All right, is there a second to that? All right. All those in favor say aye.
Aye.
Any opposed? All right, hearing none, that bill is also conformed, and having already reported out from this committee and the floor of the House, is there a motion to report now the substitute?
Move to report the substitute.
Any further discussion? Okay, hearing none, please record your vote.
I was just going to say, I think there were some no votes on the other side.
Okay, please close the roll. And the substitute reports.
Mr. Chairman, members of the committee, thank you very much.
Thank you, Senator.
Just in time.
All right, the last bill on the docket. Senate Bill 1507.
Not sure how to take that, Mr. Chairman. Senate Bill 1507, I believe, is similar to one that you've heard before from Delegate Hope.
It passed.
Okay. So, and it's a report of the Behavioral Health Commission. It's just cleaning up some work in the process of how this work is done. I believe there is a slight difference that y'all may know about, and I believe that my bill is preferable, although there's no pride in authorship there because you know I didn't write it. But I'm happy to address any questions or differences if you like at this moment.
All right, Council, can you identify the difference between the two bills?
The difference is in the original bill, there was no time frame for when this evaluation was supposed to occur. We inserted that it had to be done within 72 hours. My reading of it is the House bill requires the evaluation to be done within 72 hours. The Senate version requires that once the evaluation is done, the court has to be notified within 72 hours. And so there's no time frame on when the evaluation is done, just that when it's done, that's when it is given to the court.
Is there any word on Delegate Hope's preference for that particular provision?
I do not know the answer to that, Mr. Chairman.
Okay.
I just
looks like someone from the.
Didn't ask, maybe Natalie or.
Okay.
Good afternoon, Mr. Chairman, members of the committee. I'm Natalie Moglioni, Executive Director of the Behavioral Health Commission. The Senate conformed House Bill 1908 to the Senate version, and it would be preferred for this bill to remain as is and would take priority.
Mr. Chair.
Delegate Bell.
We actually have, I think Delegate Watts and I are actually part of that little BHC. This is the issue. The courts, the prosecutor says it's so minor we want to kick it over to the other side.
Yes,
and the question would be the evaluation being done within 72 hours or 72 hours after the eval, it goes back to the court. One would really speed it up, but it might be hard for them to comply. The House, so to speak, the House version might be hard to make work. I'm looking over at our VHC staff. The other one would take a little longer. It does mean they couldn't sit on it afterwards. Is that right? I don't know that it matters that much, Mr. Chair. The Senate language, if Delegate Hope is satisfied, I'd ask the patron, Mr. Chairman, I ask the patron a question.
certainly.
I can't imagine Patrick has a strong preference. Have you had any discussion with him? Have you all?
I just cannot represent that I have.
Right.
So, but I think you're right.
He was at the Senate committee meeting, and he was comfortable with the
Okay,
amendment.
let's just keep it the way it is. Mr. Chair, I would move to report the Senate version of the bill.
All right, there's a motion to report and a second. The bill is before us. Any further discussion? All right, hearing none, please record your vote. All right, please close the roll. The bill reports 8-0.
Thank you, Mr. Chairman, members of the committee.
Thank you. All right, I believe that concludes the docket. Is there a motion to adjourn?
So moved.
A second? Adjourned.